I'm Rob Hassett, and today I'm going to talk about what I consider the top 5 most common mistakes that are made in limited liability company operating agreements. Before I do that, I do want to give you this disclaimer. I'm providing this information for general informational, educational purposes, not for, it's not legal advice. If you want legal advice, you need to go to an attorney and lay out all the details and all the facts that apply, and you could end up with a different result than what you expect from just knowing the general principles. But the top 5 mistakes I see in operating agreements are: number 1, the agreement's not written clearly. It should be written in plain English so that it's understandable. There may be, and I'll concede this, there may be some arcane tax issues that have to be dealt with, and the language for that is not going to be understandable by most people because they need to know all the tax laws that apply to understand it. So in those situations, you could have a few clauses that aren't readily understandable, but you want the rest of the agreement to be understandable, because if you don't understand it, a judge is not going to understand it, and you're going to get a result different from what you expect. Or you could get a result different from what you expect in a case. Second, I've got them written down, you need a way out of the agreement if the parties don't get along. You need some way you can say it's for 2 to 5 years or during the entire life of the company, but you want some way that that the parties can resolve any differences by stopping their connection, stopping their association. One way to do this in the common way is to say that I can always offer to buy your units or sell my units to you, and you have to pick one or the other of what I'm offering for a particular price. And you can build other safeguards in that to make it less subject to abuse. Those clauses are usually not in there. Another thing is, I think that in many cases you don't want everybody that is going to be a part of the company to have their full allocation of units right from the beginning. You probably should have everyone vest units as they go, because if they stay 1 year and then leave, you don't want them to continue to already own, let's say, 30%. They didn't really earn but 10%. But if you do that, you need to provide for a Section 83 election under the Internal Revenue Code, which is that even though you may get your units later, you want them to be considered taxable for tax purposes as of the start of the company, because at the start it's probably not worth anything. But if you wait till 2 or 3 years later to have your units vest, and then have the tax applied at that time, it could be worth a lot of money, and you could be taxed for a lot of income that you want to avoid. My fourth recommendation is that you not have any small investors. You should have only accredited investors. That's for security laws purposes, which I'll discuss in another video. But also because you don't want to have to deal with getting consents, and you always may need consent from individuals. You don't want to have to deal with that with many small investors. First of all, they tend to be more paranoid than major investors, and they are more concerned about losing their money, and they will cause you more trouble. And since you'll have a lot of them, if you sell units that you don't charge a lot for, you sell them small percentages, you're asking, in my opinion, asking for trouble. I wouldn't do that. And then you need to make sure your operating agreement addresses all the major issues that apply to the state you're in. The operating agreements, the law relating to the law relating to limited liability companies varies from state to state, and the default rules vary from state to state, and you need to make sure you have a lawyer that knows what those rules are so they can be addressed in dealt with in the operating agreement if necessary. For example, in Georgia, we provide that if I own 100%, 99% of the company and you own 1%, we have equal vote because the voting is per capita, per member, unless otherwise stated in the operating agreement. And I doubt that's what many people would want. At least that's not what the people that own most of the company would want. So I hope that helps. If you've learned something, if you have any questions, you can email me at rob@internetlegal.com or rob@businesslawpartners.com or visit our website, www.businesslawpartners.com. Thank you.